Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a Seventh Circuit opinion that talks about the issue of standing. Now, I've covered several different times on this channel the issue of standing and what it is and what it means, but just as a brief refresher, standing is tied very closely to the concept that anything that you bring before the courts, any kind of case, has to have a real case or controversy in it. In other words, you can't just ask for an advisory opinion because the courts only decide issues that are real. And so one of the concepts of standing that sometimes gives people trouble is this whole idea of a real, concrete, and particularized injury. Because what some people believe to be an injury, in fact, is not the kind of injury that will give you standing. And that's because in order to get relief in a court can do a couple of different things. It can grant you an injunction. It can give you a declaratory judgment and say that under this contract you have the right to have your homeowner's claim defended. It can give you, like I said, an injunction to keep somebody from trespassing on your land. It can give you a monetary damages award for some harm that some other person has inflicted upon you. But in order to do that, you have to be able to present the kind of case that necessarily brings with it some kind of economic injury in order to get economic damages. And that's what's at issue in this case before the Seventh Circuit. Let's take a quick look at the opinion, and then I'll be back with some comments. This is an appeal to the United States Court of Appeals for the Seventh Circuit. It sits in Chicago, and this is Beisel et al. Versus Midvale Indemnity Company and American Family Mutual Insurance Company. Midvale is always an interesting name to me. It's in one of Gary Larson's Far Side cartoons where there's a kid at the Midvale School for the Gifted pushing on a door that says pull. That's what I think of every time I see Midvale. Anyway, this case involves an instant quote feature on these two insurance companies' website. They would offer an instant quote for auto insurance, and to simplify the process, each site would autofill some information, including the number of the applicant's driver's license. The problem was that anyone could enter a stranger's name and home address, which would lead the form to disclose the number of the stranger's driver's license. Midvale discontinued the feature after observing unusual occurrences and activity, and it notified the people who were affected. 3 of those people decided that they would sue, and they sued as class reps, but there's not been a class action certified, and it looks like there never will be. They sued under the Driver's Privacy Protection Act, and the court said, look, whether that act even applies at all is questionable. Its principal rule is directed to state officials, not private actors. But they say, look, we don't need to go there because the district court did not address the merits. It concluded the 3 plaintiffs have not been injured and therefore lack standing to sue. Now, the judge recognized that people injured by leaked or hacked data can have standing, but all of the cases that are cited there, Diffenbach, Lewert, Remages, all of these are decisions that hold that litigants must show concrete injury traceable to the disclosure. The district judge concluded that plaintiffs had not done so. For example, in Remages, it held that a need to pay for credit monitoring is a form of injury. Similarly, loss of access to a credit card, even for a few days, is an injury. But the district judge observed that neither the complainant nor any of the other papers show how any of the events that occurred could be linked to the disclosure of driver's license numbers. One of the people complained about having a brokerage account opened in his name, but Social Security numbers are used to open brokerage accounts, not driver's license numbers. Likewise with credit cards, and if a driver's license number cannot be used to obtain credit in someone else's name, what's the point of credit monitoring? That step entails expense, but the expense does not stem from the asserted wrong. Plaintiffs try to bridge this gap by contending that the disclosure caused worry and anxiety, which led to these other steps like monitoring. Yet, the court has always said worry and anxiety are not concrete injury. Now, that's kind of interesting considering that worry and anxiety are at the heart of claims regarding stalking and the sort of remedies that are available to people who claim that they have been stalked. So I wonder sometimes if this kind of opinion might later come back to bite somebody who has a stalking case up in front of the Seventh Circuit. If worry and anxiety were available, they say that almost anyone could litigate about almost anything because just about everything anyone does causes some other people to fret. Imagine someone who asserts the disclosure of my license number made me sad, and to cheer myself up, I ate a chocolate bar. The price of candy would be the money out of pocket, but eating chocolate is not a normal consequence of disclosures except through the bridge of worry. Now, obviously, these folks don't know my wife. If they did, they would understand that dark chocolate is absolutely a life's essential for some people. But I digress. The cost of a credit monitoring service is no different when the disclosed information doesn't facilitate credit-related frauds. And they cite a Supreme Court case where it says respondents' contention that they have standing because they've incurred certain costs as a reasonable reaction to a risk of harm is unavailing because the harm respondents seek to avoid is not certainly impending. In other words, people can't manufacture standing merely by worrying about some hypothetical future harm. On appeal, the plaintiffs stress one possibility that the district court did not mention. They say the bogus unemployment insurance claims that were filed in New York in the names of the two plaintiffs are a form of injury. A phony claim could cause injury, but only if it's linked to the disclosure of the driver's license, and they don't contend that the knowledge of a driver's license number could facilitate such a claim. So the suit lacks standing because unless the complaint plausibly alleges a concrete injury caused by the asserted wrong. If a license number could have contributed to unemployment insurance scams, well then they'd need an evidentiary hearing to learn whether it did contribute. And they didn't have that. Plaintiff's submission boils down to an assertion that there might be a connection. Guesswork of that kind is not enough. However, the injury must be traceable to the asserted wrong and likely rather than speculative. Perhaps anticipating that we would reach this conclusion, plaintiffs maintain that a violation of the act is enough because Congress provided for an award of liquidated damages. Well, they did that in other statutes too, and unfortunately, those decisions don't help you either, because this line of argument is thoroughly incompatible with TransUnion versus Ramirez and Spokio versus Robbins. No standing despite the court's assumption that the defendant had violated the statutes. So, they ask, does any state make disclosure of a driver's license number tortious? They say, not that we can see and not that plaintiffs have found. And then they go into a little dissertation about how driver's licenses are used, including for voter registration. Many people thus know the numbers on strangers' licenses. A license number is not viewed as embarrassing, like a low grade point average. So really there is not anything that ties it to a concrete injury that would in some way cause harm to these plaintiffs. They say plaintiffs have pointed to only one decision after TransUnion in which a court found standing for persons complaining about a violation of the Driver's Privacy Protection Act. Gary versus James S. Farron, PC. That decision illustrates the need to be precise when thinking about invasion of privacy. Plaintiffs in Gary alleged that the defendants disclosed not license numbers, but home addresses, which attorneys then used to send unsolicited ads. As in junk fax and robocall cases, the analogous tort is intrusion on seclusion. Our plaintiffs, by contrast, do not allege that any of the information that Midvale leaked has had a similar result. Plaintiffs have not plausibly alleged that Midvale's disclosure of their numbers caused them any injury, and the disclosure of a number in common use by both public and private actors doesn't correspond to any tort. It follows that plaintiffs lack standing to sue, and plaintiffs who lack standing cannot receive either damages or an injunction. Lawyers often try to make a mountain out of a molehill in some of these cases. The Most recent vehicle for this has been the Telephone Consumer Protection Act, where people got robocalls. And if you violate the Telephone Consumer Protection Act by making repeated robocalls when you're not authorized to make those calls, well, then you can get a civil penalty or basically liquidated damages asserted against you. And very much like what the Spokio case stands for, which was Fair Credit Reporting Act, I think. And then the other case, and this case, which is basically statutory damages do not create standing. And as a result of that, you actually have to receive some harm. You have to be harmed in order to bring any kind of lawsuit, but certainly a class action. Now, class action claims don't have to be for lots of money. They can be for smaller amounts of money. The idea is that you have to have been harmed. There has to be money taken out of your wallet by what happened. Or you have to have suffered some real concrete physical injury as a result. That's what I have for you today. If you have an opportunity today, please go out of your way. Do something nice for someone. Tell somebody they look nice. Tell somebody that you like the car they drive. Just do something to brighten their day. I can guarantee you'll feel better about yourself and the rest of the day if you do that. Do that and then come back and catch me down here at the beach next time tomorrow. Have a great day, guys. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.